responsibility, but the attorney who presents the document in the hearing has a duty to put it, and the rule could just be adapted slightly to say whether it is filed with the court or presented in an administrative or court hearing of any kind, the confidentiality sheet or the redaction policy must be applied, because there are plenty of types of procedures, not just domestic relations, where you might have that and the policy could be defeated. But going back to the question on the appeal, if the reproduced record is not going to be part of the electronically available record, then the fact that I stamped it confidential and it was subject to a confidentiality agreement, since that reproduced record isn't going to be available anyway, 90% of that concern isn't going to exist. Because it's only if the judge cites it in his opinion, going back to my original comment, that it becomes problematic.
So, going on to Section 9. So this is information that an individual can see when they get to the courthouse. There's just a few little changes here. There are two specific case categories that the policy really is focusing on safeguarding. And this is birth record cases and incapacitation cases, guardianship matters. And in these matters, the court orders, the court opinions, the order adjudicating a person as incapacitated, the docket, they'll remain accessible to the public. The rest of the information will not remain accessible to the public. Other than that, it's stuff that we've already talked about. The confidential information form or the unredacted version, or excuse me, the redacted version of the policy or unredacted version will be inaccessible. Any document filed as a confidential document will be inaccessible. As is today, anything sealed, pursuant or protected by a court order is inaccessible. Information to which access is otherwise restricted by federal law, state court rule, as today is inaccessible. There is a general catch-all provision in there about information determined by the court administrator of Pennsylvania with the approval of Chief Justice. This is a provision that's been in all the policies that have been implemented over the last decade. This would be some sort of safety valve that if there was some statewide concern about the release of dates of birth, that perhaps this could be a way that that could be resolved. It really hasn't been invoked in the 10 years, so I really can't even give you a good example of when that would happen. But it's not something that would be done on a case-by-case basis. It would truly be some kind of a statewide basis. If it was done, there would be notification in the public bulletin and other places, so we would know that. But, with regards to the information restricted by existing law, I mean, I know we're talking to attorneys here, but when we talk to court staff, we're often asked, well, what does that mean? If you practice in criminal law, everybody knows in criminal law that unexecuted search warrants are inaccessible to the public until executed. That's because of Rule 212. If you don't do criminal law, you may not know that, you may not find that. We created a handy 6-page chart where we tried to list as best as we could all the existing statutes, rules, court opinions that deal with family court matters, the really big ones. It's a nice handy guide. You may want to have it handy. It's on the website. When you go look at the policy, which I know you will, you'll find attached to the policy that restriction. That brings us to our final big bucket, bucket 10, our practical obscurity bucket. This is information you can see at the courthouse, you cannot see online. And this is prospective, so let's just make sure that this is important. For those counties that have a website and have things online already, whatever's online as of January 5th, 2016, it's online. Come January 6th, it's only when you start posting things online January 6th, January 7th, January 8th, does this policy kick in. So if there's a document online January 5th that has social security numbers on it, financial account information, it attaches a medical record and a tax return, that same document is accessible online January 6th. The policy does not require you to take it down. But any new documents have to comply with the policy. So just alerting you to that fact, that if you've been involved with cases and your client's information is online, this policy is not going to help you. It's only going to help you moving forward. So, information, anything that we said you can't see at the courthouse, you can't see online, obviously. Juror, witness, victim information in criminal cases will not be accessible. Transcripts lodged of record, except if a portion of the transcript is attached to a motion, that's fine. but the entire transcript's not accessible. IFP petitions, for obvious reasons of all the information you have to put on there. As already mentioned by the judges, original and reproduced records in the file and the appellate courts will not be online. And in our last two, family court records, a docket, and I'll explain that in a minute, can be online, as well as the court orders and court opinions. And essentially in all the orphans court matters, same type of idea. Court orders, court opinions can be online in the docket. When I say docket, we mean a limited docket that has a party's names, city, state, zip of the parties, council of records, name and addresses, docket numbers, the docket entries that generally tell us what's going on, court orders and court opinions, and the filing date. So therefore, you're still able to see a lot of information online about these cases, but they are of a sensitive nature that if you want to see more, you're heading down to the courthouse. And with that, Andrea is going to take us.
That provide consistency in access protocols so that when a member of the public goes into any county, they have essentially the same experience. The first principle on that screen speaks to that, those provisions, and actually the court, in issuing its implementing order in January of this year, directed each judicial district to evaluate the continued necessity of its existing local rules that required a redaction or specified access protocols. By way of an update, numerous judicial districts have submitted proposed local rules to our implementation committee for review. We are actively doing that and anticipating that we'll be communicating back with the president judges and district court administrators so that they can promulgate these local rules, publish them so that the local bars and the public are on notice about how to handle confidential information and documents in that judicial district. And as David said, I really anticipate that you'll start to see those local rules published and promulgated starting in September. The remaining principles on the screen appear in the Magisterial District Court record policy that was mentioned previously and reinforces the notion that basically the filing office is the custodian of the record, must balance access requests with its primary business, which is, processing cases. This next slide, very simple, underscoring the judiciary's commitment to the presumption of openness of its case records, grounded in Article 1, Section 7, 9, and 11 of the Pennsylvania Constitution, as well as common law. The longstanding tradition of access to court records in our Commonwealth and the important interest it serves are best described in the case Commonwealth versus Fenstermacher, assuring that justice is done even-handedly and fairly across our Commonwealth to prevent decisions based on secret bias or partiality, to prevent individuals feeling that the law should be taken in the hands of private citizens, to satisfy the natural desire to see justice done, to promote open government and access to government by the citizenry, and to promote an understanding of our government. Section 4 is how a member of the public can make a request for access to court records. It's very straightforward. The term public is actually defined in Section 1 of the policy. It excludes parties to the case, attorneys of record, unified judicial system officials, and other government officials and employees acting in their official capacities. While we anticipate and know that most requests for trial and appellate court records occur by someone coming to the filing office usually and requesting access to the case file, the policy does, in the commentary, require the AOPC to publish a written request form, much like we've done in our other policies. And we anticipate that this form will be released again in the very near future. Section 5 deals with how the custodian, the filing office, is going to respond to that access, public access for court records. And again, equally straightforward. Most of the time, if the records are not online, then this is an over-the-counter transaction. The policy recognizes and affirms that these requests should be filled promptly, unless there are circumstances that might slow the process down a bit. Perhaps the filing office, the requester wants, an archived record that's stored off-site, or is requesting a large number of records that must be retrieved. If the custodian is going to delay filling the request because of those special circumstances or deny it, then the custodian has to inform the requester why that is so. If the request is made in writing, then the custodian has to submit his or her response in writing. And in those cases where access is denied, relief can be sought by filing a motion or application with the applicable court for which the custodian maintains the records. Section 6 deals with fees. Again, it's pretty straightforward and simple. It sets a ceiling on the photocopying fee that custodians can charge for access to records, duplicating records, whether it be photocopying or printing those records from whatever electronic media that they're stored in.
Can a member of the public who's looking at records use their phone and take a picture of the record?
Yes, our position is yes, they can. There's a caveat, though, because there is an existing statute. The legislature has found that there are certain custodians that are allowed, permitted to require, or permitted to charge more than 25 cents per page. So in those jurisdictions, this limit does not apply. We also recognize, and in carrying through with online records at the state level, we permit access to web docket sheets for the appellate courts, for the criminal trial courts, for all the MBJ records for free, as well as the online appellate court opinions and dockets as well. Custodians have to post their fee schedules in their facilities as well as on their website so that there's public notice. Section 11, yes?
Just curious, does the record of a record request become a public document that can be requested?
Well, our position would be that that is an administrative record that's not addressed by this policy. So I think that might depend on what office you're in.
Okay, thank you.
So Section 7 is a concept that originated actually in our electronic case record public access policy. Again, the policy that governs what is posted on these web docket sheets on the Unified Judicial website. And basically, it's a recognition that clerical errors happen. I mean, missed keystrokes happen. Scanning errors, as the filing office is scanning in the document that you file into their online case management system, there can be misspeaks, they can miss pages. So what Section 11 actually facilitates is a very simple procedure by which a party or her attorney can seek correction of a clerical error in a case. Clerical error is defined in the policy as an error or omission appearing in a case record that is patently evident as a result of court personnel's action or inaction. It's not, the other party didn't do this or shouldn't have done this. It is an error that results from what the filing office may or may not have done. So the intent of this section is to streamline the process for fixing in information appearing in the case record that for one reason or another is not correct, and ultimately allowing appropriate court staff upon notification to correct these inaccuracies without a court order. The Supreme Court in its 2000 Jackson versus Hendrick decision affirmed the inherent power of the court to correct errors in its records. It's important to note, though, that this is not a backdoor way for a party or her attorney to get relief for failure to comply with Section 7 or Section 8 that David talked about. The remedy for a failure to comply there is court sanction. And last but not least, Section 12, just a recognition that we all need to be on the same page. Come January 6, 2018, David has encouraged you repeatedly to visit our website, www.pacourts.us. There is a public records link up at the upper right-hand part of the page. You're going to find the policy. Soon we'll find the forms that we've talked about during this presentation, so please visit and familiarize yourself with that. This is now updated, this slide, because by the time we submitted this to Liz Simcox, the Supreme Court Rules Committees, a number of them have published for public comment proposed changes to their rules that will facilitate implementation of this policy, largely by cross-reference. The appellate court rules, civil rules, criminal rules, domestic relations rules, and orphans court rules committees, as well as the minor court rules, have submitted proposals. They're online on our website. They've been published in the Pennsylvania Bulletin. Comment on those rules, and I've heard some good comments with suggestions, so please review them and submit your comments to the rules committees. We will certainly take back, though, what we've heard today and share that with the relevant rules committee. Just to recap, policy effective date, our website. Please familiarize yourself with policy. The judges, David Price and I, thank you for attending today. We thank the Dauphin County Bar Association, particularly Liz Simcox and Bridget Hilbish, for helping us get the word out. And we're available for any more questions or comments that you may have at this time.
And there's a great article in the